Well, I'm delighted to be here with Nyah Duffy and Sarah Stowe from Buzzacott in London. Welcome to you both.
Thank you very much, David.
So there's lots to talk about with a new administration in the US, a recent budget in the UK. We're going to discuss about trusts in that context. Before we get into the meat of our conversation, it'd be great to have a quick introduction to you both. Sarah, perhaps you could tell us about the work you do at Buzzacott.
Yes, of course. I'm a senior manager at Buzzacott, working on the expat team. That means the focus from a tax point of view is the US and UK intertwined, whether that's a US person who's UK resident, a UK resident investing in the US, and just navigating what can be sometimes a tricky situation.
Fantastic. And Nyah, what about yourself?
So I'm a director in our private client team and I specialise in trusts. So I deal with UK trusts, US trusts, offshore trusts from a UK perspective, looking at beneficiaries' tax position, the trustees' tax position, how they're taxed in the UK. And we have to apply certain rules to that to establish the position, basically.
Great. So by way of background, why do wealthy people use trusts? Why do the structures exist? Sarah, perhaps you could give us a bit of context for the conversation.
So it isn't limited to wealthy people. Trusts in themselves, they're there these days primarily for asset protection and planning for estate purposes, deciding how assets are going to transfer through multi-generations. So since the 2006 changes, trusts in themselves haven't been the most tax efficient from a UK standpoint, but they're still very relevant when it comes to estate planning and how you wish to transfer wealth throughout the ages.
And Nyah, perhaps you could tell us a little bit about the different types of trust structures that people might encounter, both in the UK and overseas.
So from a UK perspective, you've got three main types of trusts. You've got a discretionary trust, an interest in possession trust and a bare trust. And depending on how the trust is, the characteristics of the trust will depend on how it's then taxed in the UK. So the legal owners are the trustees and the beneficial owners are the beneficiaries. So it's very different to holding an asset personally. And if you have a discretionary trust, the trustees have discretion over how much they pay out to the beneficiaries. So it's up to them. The beneficiaries do not have a right to anything. Whereas with an interest in possession trust, the beneficiaries do have a right to either, it can be the income or the right to live in a property. And then you have a bare trust, which is generally if you're a child and your parents are holding a bank account for you, that's technically a bare trust. So they're holding it, and as soon as you turn 18, you can ask for that. That is yours. You have a right to it from that point. And those are the three main types we look at, and depending on how the trust is classified, which you would find out by reading the trust deed, depends on how they're taxed for UK purposes.
And US trusts, how are they different?
So they're very different from the UK trust point of view. A very commonplace for US trusts is probate planning. US domestic person wants to avoid the complex and often burdensome forms of probate in the US, puts all of their assets into a US revocable trust. Now, they decide they want to move to the UK, and their position on that trust is they're often the settlor or grantor for US tax purposes, the sole trustee and the sole beneficiary. For US purposes, there's no change to their income tax than if they held those assets themselves. They suddenly need to move to the UK, and that's when Nyah needs to have a look at this deed, decide what it is from HMRC's standpoint.
So how are they recognised in the UK then, these US trusts?
Well, that depends. So we have to have a look at the deed, look at the characteristics, apply US law, and then look at the UK position and whether that would be a discretionary trust, an income and possession trust, or a bare trust. A lot of the time they're bare trusts because we don't have a similar concept in the UK. We don't have a trust that you can put everything in to then avoid going through probate. I think the US, one of the main reasons is that it's very expensive to go through probate, whereas in the UK we don't have similar issues. We have a very good system set up. I'm sure people would disagree, but in terms of US, you get through it much quicker and it's not as expensive. So that's one of the benefits. But they can be treated as substantive trusts for UK purposes, so a discretionary and an income and possession. And again, depending on how it's classified will depend on the tax treatment for UK purposes.
So what about the proposed changes in the budget at the end of October 24? How are they going to impact this area of trusts?
So the main changes will be to offshore trusts and how they're treated at the moment, and it will be to trusts where the beneficiary and the settlor are the same person, so that someone has set up a trust for themselves. And where they've done that at the moment, they're only taxable to the extent that they bring funds to the UK, and they're currently treated as excluded property for inheritance tax purposes. Now, going forward, that is no longer going to apply. there will be tenure charges and exit charges up to 6% on capital distributions. And that will be obviously every 10 years, but it will only apply once the settler has become a long-term resident, so has been in the UK for 10 years. And it will apply, presumably, on the basis that they're not taking capital distributions, there will be a tenure charge every 6 years. And that won't go from the budget date, it will go from the initial date of the settlement in most cases. So if it was set up in 2018, the settler won't become UK resident under the long-term resident rules for another few years, then there's still a lot of time before the first tenure charge will apply. But what we've also got to look out for is that this could apply to trusts where the settler has left the UK but has not lost the tenure tail. So it could bring trusts into charge that are no longer UK resident but may still have an exit charge. And it could also work the other way in that trusts that were UK resident which have left are now no longer UK resident.
So what kind of computations are going on at the moment? I mean, these are proposed changes, but what are advisors doing at the moment with trustees or with families to try and work out the implications?
I think the main thing trustees can do at the moment is make sure their records are up to date, find out exactly where their beneficiaries are, because we've had a few cases recently where the trustees have thought the beneficiary is living at home, the beneficiary has gone to school, and they've gone to school in the US, for example. And that can create all types of problems from a distribution point of view if they are receiving distributions from the trust. So the trustees just need to make sure the records are up to date. I would update any stockpiled gains pools and relevant income pools, just so that if there is some planning to be done before the 5th of April, we can look at it and establish if we should realise gains, if there's a benefit to the trustees of doing that.
Because there is some beneficial rates around remittances, aren't there? I mean, does this have any impact on that?
Yeah, so there may be the opportunity for people who have used the remittance basis in the past to bring in some funds that, by using the remittance basis, they've not paid tax on them because they've not brought the funds to the UK. There may be an opportunity to bring those to the UK and pay a lower rate of tax, so a 12% for the first 2 years, and then it will increase for the 3rd year. If it's income, that'll say they would normally be 45% potentially, and if it's capital gains with the supplementary charge, it could be up to 32%. So it's quite a substantial saving. They may not get another opportunity to do that. So if they have been thinking, well, maybe I want to bring these funds to the UK, wind up the structure because it's just becoming an administrative burden, this may be an opportunity to do that.
And what about other parts of these proposed changes announced in the budget, particularly relating to IHT? Was there anything in there that people are looking at as well?
Under the current regime, you would have to be resident for 15 out of 20 years to be considered what's currently called deemed domicile. Under the new proposals, that is going down to 10 years, which is quite a significant decrease. So people will really have to make sure if they don't want any UK inheritance tax implications, they would have to leave before they've been resident in the UK for 10 years. And under the old proposals, there was the sort of, you could leave and come back and then restart your clock. That's not going to be an option anymore. From the guidance we've seen, it's on a table system, so you calculate the years and then they tell you how long you can stay and things like that. But obviously it will all become a lot clearer when the legislation is released, which should be early next year.
So Sarah, we've had this election in the US. There's lots of talk about Americans coming to London to become resident for the first time here. What are some of the implications out of the October 24 budget announcements that they should be aware of?
I think it's still a really important point to remember that the UK is still, as you say, known globally. It's still a place people are going to come. Yes, these rules have changed for people, but it's still an attractive place. And somebody like a US person, they're taxed based upon their citizenship. So if you're a US person, wherever you are in the world, you will be subject to US tax. Therefore, the changes in the rules for a US person maybe aren't as unattractive as they are for other jurisdictions. And so the 4 years where you can now claim the foreign income and gains provisions are actually quite attractive. Previously, on the remittance basis, if you were to claim it, that meant you could not bring your offshore income and gains into the UK without incurring a UK income tax charge. Under these new rules, your first 4 years of residency, provided you declare your full overseas income and gains in those years, you're then not taxed on it. You receive essentially a credit, a relief, but you have free movement of that money.
And are there any planning ideas that those inbound Americans might utilise or need to be aware of as they become resident, or as you say, because they're being taxed globally, these things are less important and actually just getting the administration right is the main thing?
Well, because they're being taxed globally, the actual bottom line tax figure is less of an issue. However, there are very common investments for US people, such as US mutual funds, which actually don't receive favourable treatment in the UK. And this now gives them a 4-year window to decide, do I want to stay in the UK? If so, they can maybe start investing in more UK, US tax-friendly investments in that time without suffering any penal tax rates.
And what about the tax reforms planned by the new administration in the US? Is there any sense of what might happen or how are clients reacting?
So from an income tax perspective, we think things will stay pretty much as they are. President Trump on the campaign trail said that if he got into power, he would make sure the Tax Cuts and Jobs Act, which is due to sunset soon, will be made permanent. Therefore, the income tax rates and the brackets will stay the same. One thing he did say he would change about that act was instead of limiting state taxes to a $10,000 deduction, they would go back to being unlimited. Now that can be very useful for the people who have things such as state work days, who have real estate out that they're renting still. They'll now get full deduction for the taxes they're suffering at state level. The main changes, I think President Trump has said on a corporate tax level, now that's a little bit outside of my expertise, but there are certainly people in Buzzacott who could help advise on those matters if that is anything anybody is interested in.
Are there still incentive to use trusts for US-based people coming over here? Do trusts, like you're saying on the top in the UK side, trusts have become less tax efficient here, but what's the picture in terms of clients using trusts? Is there still a good place for trust planning?
I think with the US, they're always going to be a big part of US planning because they're such a big part of the US estate planning. For example, if we look at our clients at Buzzacott, nearly every US client will have a trust. Nowhere near the same will apply to UK clients. Probably 1 in every 200 UK clients will have a trust. So there would have to be some very big changes to the estate planning in the US for the trusts to disappear. But what would have been sheltered from UK tax in the past won't be anymore. They will have to pay some UK tax as well on these. And I think the big thing for Americans is that they're not so bothered about the income tax and the capital gains tax because they pay that in the US anyway. So there's tax credits that can work in that respect. But it's the inheritance tax that worries them and they don't want to pay this. And obviously there is some grandfathering provisions where if the trusts were set up pre-budget, they will not. What would normally happen with a settler interest trust is they would form part of the settler's estate on their death and be subject to 40% tax. What has been announced in the guidance is that won't apply, but exit charges and tenure charges will apply. So that's 6%. So you're looking at a very different rate of tax. Although the tenure charges will apply every 10 years, the 40% would only apply once. But given the time frames that you're looking at, usually with these type of structures, it will take a lot of years to get to that 40%.
I think it's also a big culture shock for a lot of our US clients. The thresholds for US estate tax are considerably higher than in the UK. So currently, they've got a $13.99 million lifetime gift and estate tax exemption, which compared to the £325,000 sterling exemption in the UK is a huge change. And under President Trump, if he doesn't do anything, that is set to half in 1st of Jan 2026. Now, he hasn't confirmed one way or the other, but based on his previous comments on US estate tax, we think he'll probably look to set the rate higher. So it really is important for a US person coming into the UK to be aware that the UK has very different thresholds and very different rules around estate tax.
Have you noticed a pickup in Americans being interested in coming to the UK, or is the trend fairly steady as it goes? What do you see?
We've definitely had a lot of website inquiries recently from US people looking to move out of the US and come to the UK. And I think what's very good timing, depending on how you look at it, is the 4-year foreign income and gains provisions, because that's an election. So that's a cycle. They could come to the UK, make the most of the rules, and then go back to the US in 4 years' time.
And so clients affected by these matters, I mean, how do you help them? And also, how do you work with the other advisors they might have around them? It'd be interesting to hear what how you bring value to the clients and the team around them.
So it's looking to see where we can effectively make it work best for the client. I think the thing with trusts is it's a common misconception that they're used to avoid paying tax, which is not what they're for at all. They're structures which help to preserve family wealth and pass down to the next generations. So if you're paying all your money out in tax, that there's nothing left. But at the same time, they pay tax, and they pay tax at the highest rates usually. So they're not an offshore structure which isn't paying any UK tax. They are. And it's looking to find the best position for the beneficiaries. So for example, in the current regime, you've got protected settlement rules. And how they apply is that the beneficiary is only taxable, or the settlor beneficiary is only taxable when income is distributed out. In a lot of US cases, we taint these settlements because we want them to be taxable on an arising basis because they're taxable in the US on an arising basis. So it's looking at things like that and just making sure they're still fit for purpose. If we're taking on a new trust, we'll do a trust review, and one of the first questions we will ask the client is, what is the purpose of the structure? What are you trying to achieve? And a lot of the time, what they want to achieve isn't being achieved by the structure, and actually something's better, or we can look at restructuring it to then achieve what they do want. And a lot of the questions we get from new clients will be based around, they come to you and they say, I want to do this. Well, we've got to drill into it, look down. What they actually want to do isn't what they thought they wanted to do in most cases.
So based on the proposals in the budget, is the domicile regime over?
I mean, it's difficult. Domicile will not completely disappear because it's linked to a lot of tax legislation, but the deemed domicile provisions will no longer apply and instead will be replaced with this long-term residence. I think because we've not seen the legislation yet, it's going to be very interesting to see how the tax treaties all apply, because at the moment, domicile is linked to a lot of the tax treaties.
Yes, and they've actually come out and said they certainly aren't going to renegotiate the double tax treaties in place. And there's not only the income tax double tax treaties, which do focus on domicile, particularly when you're trying to decide whether an individual who is dual resident and domestic law in both jurisdictions, where they actually fall as tax resident, that is still based on domicile. But there's also gift and estate tax treaties. The UK and the US have one that we commonly see, and that is also based on domicile. So although domicile is dead for an income tax purposes, it certainly isn't, and it's going to be important that we keep reminding clients, trustees, anybody who comes in touch with individuals who move about the world a lot, to make sure that they are comfortable with what their domicile is under common law purposes. Even though it might not have an immediate impact onto what will be on their compliance tax return, it is certainly a consideration for future planning.
Because it may affect the availability to use the double tax treaties if they are not considered to have a non-UK domicile anymore.
And what about UK resident beneficiaries of trust structures moving to the US to become resident there?
The first question we would have in that instance is what visa they're moving on. The most common place I see it, and I don't know if you agree at the minute, is that we have a lot of UK resident beneficiaries moving over to the US to study. The US is still seen as a fantastic place to go to the university. Now, if they're on a student visa, of which there are a few types, they actually can receive quite good federal income tax treatment, as they're essentially treated as a non-resident for income tax purposes. Now, that is at federal level only, so it also has to be reviewed as to what state they're going to be resident in. Some states don't recognise this exemption. But it does mean that with enough planning, you could have a situation where they are living in the US, they are resident for the number of days, but not actually tax resident. So they can receive a distribution from an offshore, by which I mean non-US, in this instance, trust, without paying any federal tax. However, there is a slight exception to that, and that is capital gains. Capital gains would be taxed at 30%. Normally, for trust perspective, we're not worried. However, for offshore trusts in the US, any current year income also includes capital gains. There's planning that can be done, there's elections that can be made. However, these elections are irrevocable. They work very nicely if that student is going to leave after 5 years and never come back to the US. However, the US is an attractive place to live.
Life gets in the way, doesn't it?
It certainly does. People get green cards, and what we don't want to happen is somebody make an election up front because it works for 2-3 years, find themselves in a situation that causes problems.
So considering the time horizon, likely time horizon, and implications of that decision.
And just reviewing, if you are a trustee, you need to be sure you know exactly where your beneficiaries are, how long they've been there, what visa they're on, and just monitor the position every year so that if they do get a passport or a green card, you know about it, because it will change the tax position for the beneficiary in the US. And you may have reporting requirements under FATCA that you have to do as a trustee every year.
So how do you help clients with these issues?
So we just help them, we review the position, we look at what they want, and from a tax perspective we can help them where they're moving from the UK to another jurisdiction and do some pre-arrival planning, departure planning. What me and Sarah look at mainly is UK-US clients, so clients going between the two jurisdictions and how we can help them, how they can set up their affairs that work well in the jurisdiction they're moving to, because obviously, as Sarah touched on earlier, there are certain investments which are very bad for UK tax purposes and some other ones that are very bad for US tax purposes.
But Buzzacott as a whole, we offer a wide range of services. We can help with corporation tax, we have charity work, we have financial planning team. And actually what works really nicely is all the teams interact, and we actually have clients who use multiple teams, which I think can be a very efficient way of managing their affairs and knowing there's still one point of contact.
And it's good for the client not to have to go to multiple people at different firms, and everyone knows the full picture of the client, and we always make sure each team is involved with any decisions that are taken.
And those who want to find out more can visit your website or connect to you on LinkedIn.
Fantastic, yes, thank you.
Absolutely. Nice to talk to you.
Thank you.